on managing intellectual property risk, with the discussion around some IP protection, freedom to operate risks, litigation and insurance. Just a couple of housekeeping points to begin with. The session is recorded, so if you really enjoy it, you can come back and watch it again. We'll also be dealing with questions at the end, and you can type your questions into the Q&A box. We'll address each of them at the end of the talk. So kicking off, an introduction. Who are we? Well, there's me, Patrick. I'm a partner in FB Rice's Life Sciences team. My primary practice is freedom to operate searching and helping our clients find and navigate IP risks. After me, David will speak. David's a litigator from Cause. He has a lot of experience with complex IP cases across most technologies. He also works across multiple types of IP rights in his litigation, and he has experience both asserting and defending against infringement claims. And then Daniel is a broker from SRG Group who has 22 years experience in the insurance industry. He works across all ranges of businesses, so non-profits, SMEs and large corporates. He's based in Perth, but SRG have offices across Australia. And just to make himself sound more interesting than David and I, he just let me know before that he's a restaurant judge as well. So hopefully that works into his talk. All right, so we'll jump into what we're going to talk about. Initially, I'm going to give just a high-level overview about protecting the IP and freedom to operate risks. David's going to talk about the litigation process and outcomes, and then Daniel's going to talk about it, IP insurance. So let's jump in. That's great. You've come up with your fantastic new product, but you don't want anyone to copy it. So what do? You come and talk to your favorite IP attorney. You protect it. So what can you protect? Well, here's an example. I'm giving a pharmaceutical example because that's the area that I work in. If I came up with this, I would have been pretty happy as well because it's a top 10 selling drug in the world. So what can you protect? Well, you can protect lots of different types of IP. So you can protect trade dress. So the way something looks, your packaging or your branding, your trademark, in this case, the word, for example, Enbrel, which is here and here. The design, so the way something looks, so the auto injector here, the way that it looks. Patenting, you can patent a lot of different things. So, for example, the drug itself, how it's used. So this drug's used to treat rheumatoid arthritis. The auto injector and all of its parts. Trade secrets are fantastic as well. So, for example, in the case of a drug, you could keep secret the way it's manufactured, your marketing plans and client contacts, and you also have copyright as well in your marketing documents. But you do need to think, what do I really want to protect? Because a lot of IP costs. So patents, some trademarks, so registered trademarks and designs are registered and they cost. So you need to think about, where do you want your protection? So where are you going to make and sell it? If you're going to sell in the United States, you might not need your trademark in Saudi Arabia. Do you need to use a registered right? Is the other question. Because things like trade secrets, they're useful. They last for as long as something is a secret, and having inverted commas there, they're free. Well, you don't pay to register them, but you do have to pay for all of the measures you take to keep something secret. Okay, so you've protected it. Let's start selling. Let's make some money. The potential issue, though, is your freedom to operate. So, freedom to operate is where you may infringe on someone else's IP rights. Just because you've patented something doesn't mean that you are free to use it. So you may want to become aware of third-party IP rights. You don't have to go looking for them. The way that you could become aware of them is that someone might sue you. So what rights should or can you become aware of? Patents. So the patents could protect the drug, its use, how it's made, again, the auto-injector and all of its parts. And they might not specifically claim, the patent might not specifically be specifically targeted at you. They just might be a generic claim that you fall within the scope of. Oops, sorry. Wrong button. User error. Trademark. So someone might have already registered a very similar trademark to yours, like Embrel. Trade dress. So your product or your trade dress might be very similar to somebody else's and you could be sued for passing off, for example. The design, so your auto-injector, the design of the auto-injector could be protected by somebody else. And the other thing to think about is if you've employed somebody from one of your competitors and they've helped you develop your, whatever it is you're going to sell, did they use a trade secret of the competitor? And this is actually an area where we're seeing a bit of litigation, seeing it in the pharmaceutical industry. It's a very expensive litigation and it can be from helping to develop products to taking client lists from one employer to the next. So how do you find out about intellectual property risks? Well, you can do some freedom to operate searching. As I said, that's one of my primary areas. I work with a team that does a lot of patent freedom to operate searching. You can also search for trademarks, designs, trade dress to some degree as well. You can, I would say, before you launch your product, search broadly for everything, but you don't have to, but you do need to think about it a little bit. For example, where are you going to manufacture and commercialize? If you're going to make it in Australia and sell it in Australia and never move offshore, you may not need to worry about a patent in the United States. When will you manufacture and commercialize as well? So a lot of registered rights, or all registered rights, have limited lifetimes. In the case of a patent, that's generally 20 years. So if you're going to be commercializing in 2035, you probably may not need to be searching for patents that were filed in 1980. As well as searching broadly for everything, it's good to do some focus searching on very important aspects of whatever it is that you plan to sell. Also update your searches. Patents change, the patent landscape changes all the time. On a daily basis, it's changing. So you can look one day and might not see a risk, and you can look 3 months later and there is a risk. And whatever risks you do find, it's worthwhile watching them as well, just to see what happens there. I would say that no search is perfect, but a good search is useful for risk identification and risk minimization. And also just, yes, risk identification, going in with your eyes open. Some other things that you can do is try and make your trademarks and trade dresses different to your competitors. Talk to your employees who have moved from competitors. Talk to them so that you know what they're doing, that they're aware of their obligations of confidentiality to their former employer. And also it's worthwhile documenting what they do. I would say stage your approach, freedom to operate searching. You don't have to do everything at once. Pick the most important things, the unchangeable things, and start there, and then move on from there. But I would suggest it is good to be ready when you do commercialize, because some of these are significant amounts of money that can be awarded in damages in litigation, up into the billions of dollars. These cases here that are listed here are in the US. And why I said think about everything, this is an example. This is actually from some European litigation. So, and it's got to do with an auto-injector like this. So Sanofi sued Mylan, and what it is, see this little black thing here? That's a little tiny clip that stops the cartridge with the drug from rattling around. And that's what the patent litigation came down to. So, so what do you do if you do find a risk? Well, there's a few different ways that you can deal with it. Avoid it. Patent attorneys love to say, avoid it, invent around, but sometimes that's harder to do than for us to say it. There are often other considerations. For example, regulatory considerations might not allow you to change things. You could take a license, so you could approach the owner of the intellectual property to take a license, or you could try and invalidate the third-party intellectual property. So in the case of a registered right, you could oppose or take a revocation action, and David will get onto that, and as I said, litigation. And you've spent all of this money getting your own registered rights as well. You can also be on the lookout for somebody infringing your intellectual property or just trying to copy you. So you can approach them to offer the license, to sue. You could just sue them. If you're going to sue, I'd say you probably need to get ready to defend your intellectual property. Most people will usually counter-sue to invalidate your intellectual property. But the thing that you should do is also talk to David. That's the end of my session, and David's going to take over from here.
Thanks, Pat. I'll just bring up my slides. There we go. So where I will kick off is talking about the IP enforcement part of things, and that involves steps up to and including litigation. So you've done the right thing as a good corporate citizen insofar as IP is concerned, and you've gone off to FB Rice and you've obtained freedom to operate, and you might also have obtained IP protection or registered IP protection in terms of registered rights, patents, designs, trademarks, and you then are intending to launch a product, or you are intending to enter the market, or you're in the market and you identify a third party that is infringing your IP, and you're shocked that there are those other corporate citizens that are either infringing your IP, or somebody's alleging that you're infringing their IP, even though you've got advice that tells you that you're going to be absolutely fine. What happens next? Typically, that's where, before there are any court proceedings, you engage in correspondence. So if you're the rights holder, you will send a cease and desist letter. And that is a letter of demand that a rights holder will send to another party saying, I hold these rights, I hold this trademark, I hold these this patent, and you are threatening to engage in this conduct, or you are engaging in this conduct, you are selling this product, you are using this brand name, and I regard that as an infringement of my registered rights, or my rights. And that will typically conclude with a list of demands. And the first demand will be that the infringer must stop doing it. That is, stop selling your product, which might infringe the patent. Don't use that brand name. It might also include a list of other demands, which might involve claims for compensation. So let us know what your profits were, profits that you made by reason of selling an infringing product, and we will then assess how much we want from you. And it might also include demands that you deliver up any stock to the rights holder. A letter of demand might result in a number of options. The rights holder might, when you respond to a letter of demand, stand down. You might be able to persuade the rights holder that in defending the claim, that their claim is without merit, or as Pat alluded to, that the underlying rights are invalid, and if they pursue them against you, you will revoke them, and then they will be lost against the world. And the rights holder might simply reserve its rights and go away, or acknowledge that that they won't pursue the claim. B, the infringer might comply with the demands. And we often see this in straightforward cases where, for example, there are counterfeiters who receive letters of demand to stop selling hats that say Louis Vuitton on them that are not made by Louis Vuitton, and they very often will simply comply because they're concerned about the next steps. Or there might be a compromise. So it might be the case that that the party that receives the letter doesn't agree with what's said, but both parties agree that rather than having a dispute continue, they should agree to resolve it, and that might involve a license for the IP, and it might involve a grace period of time for the, I'll call them the quote infringer, to trade out existing stock or change their name. The benefits of pre-litigation correspondence is that it enables you to understand the other side's position before you're in court and before you're incurring those costs. And it's certainly something that's worthwhile. For it can be a game of brinkmanship. So when you receive a letter of demand, that threatening to sue you, often the infringer might think that the claim is a bad one and might want to test the rights holder's resolve to take it any further. Are they actually committed to this? Will they incur the cost of actually commencing proceedings? So it's a bit of a game of poker. And finally, it's unavoidable because the Civil Dispute Resolution Act requires parties to engage in genuine steps to resolve disputes before they commence litigation. So if you don't do that as a rights holder, that can have consequences for you in terms of costs, which we'll come to a little bit later. So you've engaged in pre-litigation correspondence. That's not gone well, and it's necessary to commence proceedings, or somebody sued you. Where have they done that? Almost always in the Federal Court of Australia. That's always true, well, almost always true in respect of patent disputes. The Federal Circuit Court sits below the Federal Court. It has jurisdiction to hear trademark and copyright disputes and disputes about misleading or deceptive conduct. The Federal Court has specialist lists for trademark cases and for patent cases, and those judges have experience with those matters. Some of those judges had experiences in relation to those types of IP disputes while they were barristers or lawyers. And in the Federal Circuit Court, there is one specialist IP judge who case manages all of the IP cases. In each case, there's a right of appeal. So if you're unhappy with the outcome in the Federal Court, you can appeal to the full court. The full court is a panel of typically 3 judges taken from their members of the court in general. So they hear cases at first instance as well. And they will review a case or a decision and consider whether they should allow an appeal. The subject matter of those disputes, so patents, trademarks, designs, copyright, misuse of confidential information, passing off or misleading or deceptive conduct. So they're cases which can be about brands or about trade dress, as Pat mentioned. And the cases will typically, as Pat mentioned, involve allegations that by the rights holder that there's infringement. And typically there will be 2 answers to that by a defendant. The first is that there's no infringement. And the second is that even if there is infringement, the underlying right, be it the patent or the trademark, is invalid and should be revoked or cancelled. And typically those issues are heard in one proceeding together. The Federal Court also hears appeals from IP Australia, so IP Australia will make decisions about what rights should be granted and hear oppositions to the grant of rights, and the Federal Court has jurisdiction to hear appeals about those issues. Now coming to the more interesting part, why do parties go to court? What can they achieve? What are the outcomes? So when you commence proceedings, you can ask and you seek the following outcomes and by way of orders. The first typically sought in IP cases is a permanent injunction. The rights holder will typically seek to restrain the defendant from engaging in the conduct, that is, stop selling the particular product that infringes a patent or a design, stop using the brand name. The rights holder might also seek damages, so for example, lost profits or a reasonable royalty to compensate them for any infringement that's taken place, or an account of the infringer's profits. So they'll try and get an order stripping the infringer of the profits that they've made by virtue of the infringement. Where revocation is an issue, the court can make an order that a relevant IP right should be revoked or cancelled, and that's a risk obviously to the rights holder. The court, and we'll get to this in a little bit of detail in a short while, can and will make orders for costs. So the successful party in litigation typically gets an order that the loser pays its costs. That doesn't mean all costs, it means typically costs which are about 60 to 70% of their actual costs. Finally, the court can make declarations. So that is a statement about what parties can and can't do, what's permissible conduct and not. And this can be, I think, relevant in particularly a patent context if you're concerned about your freedom to operate and another party hasn't agitated the matter. You can ask the rights holder to admit that your product does not infringe. And if they fail to do so, you can ask the Federal Court to grant you a declaration that your product does not infringe, and that will give you commercial certainty. And finally, delivery up and destruction of goods. So just moving forward to the process. The IP litigation process typically starts with pleadings, which are court documents that outline the claim, and the defendant will then defend the claim. So they'll admit and deny allegations that are put against them, and that's just a legal mechanism to define the scope of the dispute. The next step is mediation, or possibly mediation. And it can be the case that you might want to commence a proceeding but not go all the way to trial. And the court might suggest that it's a good idea for the parties to get together and with an independent mediator who might be a registrar of the court, provided at no cost to you, and see whether they can broker a resolution before the matter goes any further and the parties incur costs. And that can be a helpful way to resolve a dispute at that point when parties are already in litigation and they can see that the stakes are getting higher. I've mentioned there in interlocutory injunctions. I'll come back to that because they're quite relevant to IP cases. The matter typically proceeds by the parties filing written evidence. So there are exchanges of that, and that's by way of an affidavit, sworn or affirmed written statements. It can be expert evidence in nature, so explaining why a particular product might infringe a patent, why it has certain features claimed, or it can be lay witness evidence. Then if there's expert evidence, the court typically adopts a process whereby experts enter conclaves, and that's a forum where the experts decide between each other without any lawyers present what technical issues they agree on and disagree on, and then they produce a report for the court, and we wait apprehensively to find out what they've done. And that's typically to narrow the scope of the dispute. There might be discovery, so a requirement, compulsory requirement for parties to produce documents before getting to trial. At the trial, typically, the federal court will, where there are expert evidence, where there are experts involved, have them all give evidence in the box at one point in time so that they can engage with each other. And that's called a concurrent evidence session or a hot tub, and is relatively unique to Australia. Common features of IP litigation. First, preliminary discovery. So it might be the case that that you think you have a patent and you think that a particular competitor is using your patented process, and you have good reason for thinking it, but you don't know absolutely for sure. And you would like to know it so that you can decide whether to commence proceedings. And there is a mechanism that enables that to happen. You need to ask the other side for the information that you need. And if they refuse to give it to you, then you can ask the court to compel them. And the court's pretty lenient when it comes to those kinds of applications. So they can be very effective tools. Even the threat of preliminary discovery can be a very effective tool to get information to enable you to work out whether, whether infringement is happening. Secondly, interlocutory injunction. So this is a really common feature of IP disputes. So bearing in mind that most IP cases are about whether a particular product can be sold or should be sold, and whether a particular brand should be used. At the outset of a particular case, it's possible for a party to ask for an interlocutory injunction. That is an order that the infringer immediately be prevented or restrained from using that product until the court has finally determined the issue. So if, for example, you find out that a competitor is about to launch a product, you will often have a rights holder rush off to court and say, look, we have a really strong argument that, that this product will infringe, and if they're permitted to enter the market, it will cause us irreparable harm. We ask the court to give us an injunction restraining that conduct now, and in 12 months' time, the court can rest assured that when it's finally heard from the parties, it's going to find that this product is infringing. And the court has the power to do that. It can be a very attractive commercial tool because it will prevent a launch from taking place and the commercial damage, but often it's necessary to go for them and get them really quickly. The cost of getting an interlocutory injunction is that you've got to agree that if ultimately you're wrong and the product was not infringing, you will compensate the party that's been held off the market. And typically you can expect that if you have wrongly held off another party from entering the market, they'll ask you for that compensation when they win. Another final feature just to mention about IP disputes in the court is there's typically a split between two parts of the case. That's liability and quantum. So the court will typically only ask and try to answer the question first of whether there's infringement. That is there a valid right that is infringed here? And once it's answered that question positively, it'll then remit the matter back to the primary judge and to deal with the question of how much the infringer should pay the rights holder. And the reason for that split is, I think, an obvious one, which is that the court and the parties don't want to typically spend time working out who has to cut who a cheque for what if it ultimately turns out that there's no infringement. So just getting to, I think, the key issues in terms of risks. The duration of matters before the federal court in IP cases. I think generally the court likes to try to get matters to trial between 6 to 12 months. There are outliers, and the outliers are generally that it takes a bit longer sometimes. There are also some cases where it happens a bit sooner, where there's expedition. And typically the court aims to deliver a decision within 3 months, but I think we generally factor in 3 to 6 months. And then you can factor in a further 6 to 9 months for an appeal. So it can be a lengthy process to get through a first instance decision to an appeal. And again, because of the split system, that's just liability. The court hasn't yet addressed the question of who should cut who a cheque for what. Costs. So costs are a key risk in IP proceedings and litigation generally. And obviously there's a cost of commencing proceedings, and many matters resolve after commencing proceedings, and that's because the game of poker really sort of ends there, where parties, thought that they'll never sue me. That's happened, and now the parties are facing more considerable risks, and that often results in a settlement. But it's possible to commence proceedings sort of in the range of $10,000 for filing, including pleadings, but the costs escalate pretty dramatically as you prepare evidence if the matter doesn't settle after pleadings, and more particularly as you approach a trial and in trial. So the complex trademark, copyright or design cases might typically cost in the hundreds of thousands of dollars if they go all the way to trial. And patent infringement validity cases, I would say, are rarely below $1 million, including both infringement and validity. And there are contributors to those costs. That's lawyers' fees, barristers' fees, expert fees, general witnesses, and moving people around the country to get them to a trial, and transcript and court fees. But as I said, the important thing is to remember the costs can be very significant, but they are not all incurred in one go. They are typically, most of those costs will be incurred either just before or at trial. And as I said before, if you are successful, you can expect to recover 60 to 70% probably of your costs, but there'll be a proportion that's non-recoverable. And if you lose, then you can expect to pay 60 to 70% of the other side's costs. So just being mindful of the time, I've just got one more set of slides to go through, and I'll go through them relatively briefly because we've touched on many of them. So there are a number of key risks in IP litigation, and potential benefits depending on what side of the equation you're on. So there's an interlocutory injunction can be an extremely valuable commercial tool to prevent a competitor from taking your market, as can a final injunction. Equally, if you go for an interlocutory injunction, there's a risk that you'll have to pay compensation. 2, damages or an account of profits. So if you are infringing, you can expect that you will have to pay compensation, and that includes relevantly court interest, which is very high. Costs, we've covered that off already. So not all your costs will be recoverable if you win, and you've got to factor that in. And if you lose, you'll have to factor in a liability for the other side's costs. Finally, and this is non-financial in a sense, but one of the risks and benefits is reputational. Parties sometimes bring IP proceedings in order for it to have a deterrent effect, for the public at large to appreciate that you are committed to enforcing your IP rights. Equally, if there is a potential of reputational damage if that all goes badly. And I'll hand over to Daniel to talk about the ability of insurance to provide an avenue to mitigate those risks.
Good afternoon. Just like to first of all thank FB Rice for coordinating today's webinar, and also to Patrick and David for their insights so far. This part of the presentation, we're going to consider the transfer of IP risk via insurance, ideally before having legal action taken against your organisation, or before you find out that you've infringed on someone else's IP, or your IP has been infringed by them. A lot of businesses, small and large, will have IP exposure, and it's important to know what type of risks can be covered. And the aim today will just to leave you with a better understanding of how IP insurance works. I'd like to advise that this is just a general introduction to the topic, and I'm not going to go into a lot of detail regarding specific policy coverage, and nothing really should be taken into account as specific insurance advice. You really need to understand the individual business and the terms and conditions of any current policy that they might already have in place. And it should also be aware that IP insurance isn't always available in every country. So look, if you have any specific questions, you can contact me after today's webinar. So this policy can cover the defence of an allegation or an enforcement against alleged third-party infringers. However, it's worth noting that most companies want to seek cover for just the defence costs only. Sometimes a level of IP cover may be found in a professional indemnity policy or a media liability policy, but sometimes those covers aren't ideally suited for IP insurance, as they may exclude certain things like patents. So the three types of commonly insured IP are patents, trademark, and copyright. But if you have other types of IP, such as design rights or trade secrets, insurers are willing to have these looked at and may be covered as well. So who needs IP insurance? Some of the things to consider are, do they already have IP rights, like a patent? They might not have IP rights, but they make use, may use, sell, or make a product or a process. They may have contractual obligations to a supplier or a client. And one of the more interesting areas is they're innovative and operate in a very competitive space. This last point can be particularly hard to establish. With the iPhone 12 being released this week, it's interesting to note that just in the US alone, there's 200,000 patents for smartphones. So whether a company thinks they're unique or has competitors, they really can't predict when a claim might be made against them. All it takes is an allegation to be brought against them for costs to be incurred. So let's consider what type of companies need IP. Well, most sectors and companies will have some kind of exposure. And this is what we kind of see a lot of, manufacturers and supply chain. This can be in health, automotive, home technologies, companies involved in the Internet of Things, even down to the packaging may have an IP risk. In relation to design, it could be anything from architects and engineers, design studios. Often mining and energy may have very specific processes that are subject to IP, especially in the oil and gas sector we see a lot of, and renewables. And obviously software and tech companies are the ones that we hear a lot about, and that can be anything from office support, platform, consumer apps, and gaming. However, it's worth noting what businesses might struggle to get IP insurance. The IP market is really involved in companies that are usually turning under $1 billion. It's not to say that we can't get them insured, but most of them start funding over that themselves over that limit. If they're involved in telecommunications, computer hardware, semiconductors, software, including antivirus protection, and some consumer electronics, some insurers may have an issue and may decline to quote. So considering the costs associated with an IP infringement, the cover can extend to other risks and exposures, but the main things that the IP insurers look to cover are the legal defence of an allegation, damages and settlements awards, and that can include past infringements, losses from being prevented from an activity, including the selling of a product, and licence fees if the IP holder is willing to allow for future use. So if you're a shareholder in a business that has a lot of intellectual property, or you're involved in the risk of a company and you want to have a discussion with the directors about how to get IP insurance, what are the things that we need to start talking about? Well, you need to look at what IP you have, what makes it unique, and is IP really at the heart of the business? Do we have contractual obligations, either to our clients or to the people that have provided us with their IP? If a claim is brought against us, could we afford to defend it or settle it without insurance? Do we have IP rights in Australia or overseas that might need to be enforced? And where do we operate? Are we aware of the local IP landscape and risks in each territory? Obviously, taking an action against an overseas company can be quite expensive. So the first thing as well that we should really take into account is, has the business had a claim before? Or are they aware of a close competitor that has had a claim? This can also be a trigger to getting insurance. Having a previous record of a loss or multiple claims or lawsuits may impact the ability to get insurance, but it really shouldn't put us off trying to get insurance. In fact, sometimes the insurance company will view that if you've had a loss and you make some drastic changes to your risk management and how you manage your IP, that might actually work in favour of getting insurance in the future for a new product or service. Often when we talk to clients about IP insurance, because of the nature of IP and it being so complex, a lot of the clients think that it's very difficult to even get insurance for. So it's actually not that hard. Sometimes with just a basic proposal form or a little bit of information about the company, the turnover of the business and what they're looking to cover, we can get just some indicative terms. For a more complex risk, the insurance company will want a proposal form, which will go into a lot more of the risk management, the products, the patents, and the IP that they're looking to insure. And for even more complex risks, insurance companies would like to have a conference call usually with a risk manager within the business or a CFO or CEO, and just really get a good idea of how the business operates and how they manage their risks. So as a final reminder, even if you have IP rights, there is a chance you can infringe someone else's. Secondly, even if you've done nothing wrong, you potentially are at risk. And thirdly, there's so much IP out there that no one can really know if they're sometimes infringing or not. This is my contact details, and I'll hand back now to Patrick at FB Rice. Thank you.
Thanks, Daniel and David. We have a couple of questions. So the first question I think came up when I was talking. Hey team, what about IP protection for books, websites, blogs, and online courses? The first IP that springs to mind to me is copyright, which is in Australia is an unregistered right. And essentially will protect you against people copying your the book, website, online course. Anything else that you could think of?
No, Pat. I think that's largely copyright.
Yeah. The second question came up when you were talking, David, and it was on one of your first slides when you said that the two parties had to there was an obligation for them to try to avoid litigation or to try and resolve the issue, and has asked, what if the infringer, alleged infringer, refuses to provide information, for example, profits from an infringing product?
Yeah, so typically you can get, I talked a little bit about requests for information and pre-trial discovery or preliminary discovery. And typically those requests are directed to the nature of the infringing product or the process, rather than the profits that are made. But it is possible to request to say, look, we know that your product infringes. We don't know if it's worthwhile suing you. And in order to make that decision, we need information about your profits and seek that financial information by way of preliminary discovery. So you've got to ask for it, be denied, and then there is an ability to pursue it. Otherwise, you'll typically get that information in the course of discovery when a proceeding proceeds.
Excellent. I've had a couple more questions pop up. Next one's probably to you again, David. Is there a time limit between becoming aware of a potential infringement and issuing a first notice?
So first, delay can be relevant to the ability to get an interlocutory injunction. So if you think that a product is about to launch and you don't do anything for several weeks or even months, and then later you say to the court, look, urgently, we need an injunction now, the court will take into account your delay, and it might be a reason you don't get that interlocutory injunction. But otherwise, each of the IP statutes has a limitations period. So you can, for example, in relation to patents, you can only claim for a period of 6 years from when you become aware of the, I think it's awareness of the infringement or when the infringement occurs. But there are limitation periods in place that will determine the period of infringement and how much is owed.
Registered designs, where do you do a search for these? There are databases for searching registered designs, depends on the jurisdiction we're talking about. In Australia, there's a designs database. Some of the paid subscription databases, for example, a couple that we use, or one in particular that we use, are developing a lot of image recognition, artificial intelligence, I guess, and they're making it easier to search for registered designs using new machine learning techniques. David, back to you. How is the court or jurisdiction chosen with products sold internationally?
So it's a jurisdiction by jurisdiction system. So a product might be made in the US and imported into Australia and sold. And if we talk about patents, for example, the manufacturer in the US might be infringement of a US patent, and the importation and sale into Australia might be an infringement of an Australian patent. And typically those patents will be owned by the same patentee. And they might commence proceedings in both countries together, and that's quite common, or they might just pursue one. So typically there's parallel court proceedings where there's different conduct in different jurisdictions. But equally, a rights holder might just elect to only sue in one because that's where most of the money is being made, and that's the financially relevant jurisdiction to sue in.
Next question's for you as well, David. Is the issue of first notice best to be issued by the IP holder, or are there traps to avoid, meaning it is best to commence through an attorney?
I think that there can be benefits sometimes in having the companies themselves engage with each other, particularly where there's a relationship or where there might be a prospect of resolving it. That said, I think it's always best to have an advisor advise you on how that should be framed. So provide you with advice on why there is infringement, so that you can frame those discussions. If you don't think that you're going to be able to resolve it, then it can often be more helpful to have a patent attorney or lawyer send the letter of demand, because you might find that it gets escalated within the, I'll call them the infringing company more quickly, sent to their lawyers for a proper response.
The next one's also for you, David. It's actually flagged as David. What's the best strategy for a small, cost-sensitive company that is being sued for infringement and their product is relatively clearly not within the claims? And the other side, not necessarily a troll, has stretched the construction of the claims unreasonably to show infringement. Very specific.
I think that one strategy is that where you're sued, obviously, it puts an immense strain on small companies when they have to face lawsuits of this type. And if they don't have insurance, then one possible way to deal with it is by asking the court to have the... sorry, I'm just making sure that I understand the question properly. I think that one way, if you think that the claim is obviously bad, is to try and strike it out, but that only applies in circumstances where you think that it's absolutely hopeless. Otherwise, sadly, you've got to defend the proceeding, which can be expensive, and the rights holder can put you to that expense, and that might be part of their strategy. And in order to defend it, litigation funding is one option, but obviously insurance at the outset can be a better one.
This question around plant breeders' rights, how they fit within the elements of the presentation. So plant breeders' rights protect, obviously, well, in Australia anyway, they protect varieties. Also varieties that are derived from the protected variety and retain all of the essential features. Dependent varieties, so varieties where you need to reproduce from the PBR protected variety, and also some harvested material as well. So that's what the plant breeders' rights does protect. David, do you have experience with PBR litigation?
No, there's been very, very little of it, and I haven't been involved in any.
Gary asked a question, sorry. I'm revising an existing entertainment concept. Should I take out a patent on the revamped version, or am I infringing on the current concept? I guess there are two different issues there. If you do come up with something that's an improvement, you can take out the patent for it, whether or not you're infringing. Am I infringing on the current concept? Well, assuming it's a patentable subject matter, you could still file for a patent application. Am I infringing on the current concept? It would depend on how that current concept is protected. If it's patent protected in its own right, you could infringe the patent. Not so sure you can infringe concept. I guess one way that I can talk to is to talk to somebody who can help you with freedom to operate searching on what you're planning on doing, and you can identify the risks there. But as I said, they're two different issues, filing a patent application and infringement. And then last question that we've got at the moment is, do we think the IP right, that IP rights and protection encourage invention or discourage it? I can.
I think that's one for you, Pat.
Yeah, thanks. Like, at the end of the day, I've never lived in a country or world that doesn't have it, so I've got nothing to compare to. But ultimately, in my opinion, I think it encourages it. I might have a vested interest in saying that. I mean, people, and I would say I also work for pharmaceutical companies as well. So people want to have a period. I think when you make something new, you want to have a period of exclusivity where you can have, where you can be the sole person selling whatever it is that you're selling. And if somebody was allowed to immediately copy what you've done and get onto the market, whether you've made something or you've got a new brand or something like that, or pass themselves off as you, then I don't think people would be particularly interested. Well, I think that would discourage invention. So I think that IP rights encourage it. Unless David or Daniel's got anything else to add, we might wrap it up now and say thanks to Daniel and David for the presentation today.
Thanks very much, Pat. Thanks, Daniel.
Thanks, Pat.
Thanks a lot, guys.